Should you take the breath test in a DUI case? Here's 3 things to consider. After an arrest for driving under the influence, the officer will usually take you to a station and ask you to submit to a chemical test. The chemical test will be a breath test if impairment by alcohol is suspected, or it will be a urine test if impairment by drugs or alcohol or a combination is suspected. The choice of what test will be administered is left up to the discretion of the officer. And in Washington, D.C., the officer could administer both with your consent. The third type of chemical test is a blood test, which is usually reserved for accidents and is performed at a hospital. But this video is only going to focus on the breath test. So here we go. Many people are confused about whether or not they should take a breath test in a DUI case. Here are 3 things for you to consider when you're deciding whether or not to consent when you have to decide. First, you do not have to take the breath test. All jurisdictions have an implied consent law, which is basically a law that says, we, the jurisdiction, extend to you the privilege of driving on our streets. In exchange, you will agree that if you're arrested for any drinking and driving offense, you'll consent to take a chemical test so that we can determine what your blood alcohol concentration is. The score won't affect anything concerning the arrest because at that point you'll already be in custody, but it will be used by a prosecutor at a later point to determine how they're going to proceed in your case going forward. Some DUI attorneys advise to always refuse taking the breath test because really it's just another piece of evidence that can be used against you in court. But that position assumes that you're probably going to test above the legal limit. But what if you really did only have 1 beer? In that case, taking the breath test could actually help your case, so you should consider it when you really know that you're nowhere near the legal limit. Number 2, the results of the test can and will be used against you. The current legal limit is 0.08 for blood alcohol concentration, so if you test above that, you'll be deemed to be legally impaired or impaired per se. More importantly, if you test with a score that's significantly above the legal limit, there could be enhancements that would include mandatory jail time if you got convicted. Also, keep in mind that you could be charged for a DUI anytime you have a score that's above 0.00. So if you're impaired to a degree that can be noticed or perceived by an officer, that would be included. Any prosecutor worth their salt will use both the breath test and the impairment testimony of their officer in court. But without the test score, the prosecutor's left only with the testimony or video evidence of how you appeared at the scene. So it may be to your advantage in court, depending upon the facts in your case. Refusing to take the test also has some consequences with the Department of Motor Vehicles, so keep that in mind. It could extend your suspension period if you refuse. Number 3, the results of a test can be challenged. If you've already taken the test or still have questions about whether refusing the test is the right thing to do, keep in mind that the results can be challenged in certain situations. These breath tests are done with an intoxilizer machine. That was a machine that was developed to measure blood alcohol levels in the breath and then calculate levels. Whether or not to take the breath test is really a decision that you should make, but at least now you have the knowledge to know what the effects would be and whether or not it would be a good decision for you. And that's news you can use.